On a humid August morning in Redbrook County, Ohio, 14-year-old Marcus Halston walked into the courtroom like he owned it. He wore his orange jumpsuit like a costume, collar crisp over the white undershirt, posture relaxed, chin lifted. His eyes swept the gallery before he even reached the defendant's table. He spotted the cameras first. Of course he did. He gave one of them a small, practiced smile, the kind a kid gives when he knows someone is watching and wants them to think he isn't afraid. The room smelled of old wood and conditioned air and the faint chemical tang of floor polish. It was a room built for consequence. Marcus Halston didn't seem to notice. He pulled out his chair slowly, like he was settling into a throne, and folded his hands on the table in front of him with an ease that made the people in the gallery shift uncomfortably. Charged only with reckless endangerment after a fire that had gutted the east wing of Redbrook Middle School, Marcus seemed convinced the system would treat him like a child who made a mistake. But behind that minor charge was a darker truth. A classmate was dead. A community was fractured. And somewhere in the recovered files of a shattered phone, a video was waiting. By the time the judge spoke his name for the last time, the laughter would be gone, and the performance would finally be over. The fire had started on a Thursday evening in late June, 3 weeks after the school year ended. The east wing of Redbrook Middle School had been left unlocked for a summer custodial crew that hadn't shown up that day. The blaze moved fast, burning through the science hallway and into the storage rooms before the fire department arrived. One person had not made it out. Darian Okafor, 13 years old, had been inside the school looking for a textbook he'd left in his locker. His mother had dropped him off. She had waited outside in her car, listening to the radio, certain he would be back in 5 minutes. He never came back. The fire burned for 2 hours. The east wing was a skeleton by the time they put it out. And Marcus Halston had been questioned that same night, calm as still water, telling the officers he'd left the building more than an hour before the fire started. Detective Lena Cross had been assigned to the case within 12 hours of the blaze. She was a compact woman in her late 30s with close-cropped natural hair and a habit of writing in green ink, which her colleagues had teased her about for years. She stood at the edge of the burned hallway on the morning after the fire, her notebook open, and looked at the scorch patterns on the floor. The fire investigator, a veteran named Hollis Wade, crouched beside her and pointed at the origin point with a gloved finger. The burn pattern radiated outward from a single spot near the supply closet. The char was deepest there. The floor itself had burned away in a rough circle. Wade looked up at Cross with flat, certain eyes. "This wasn't a fault in the wiring," he said. "Something liquid burned here first. You've got a low point of origin, radial pattern, and the burn is too concentrated for an electrical cause." Cross wrote that down in green ink. She said, "What kind of liquid?" "That's what the lab is for," Wade said. He stood and brushed ash from his knee. "But I'd bet on something accelerant-based, probably petroleum-derived." Cross spent the next 3 hours walking the hallway, photographing everything, cataloging the camera positions. There were 2 security cameras in the east wing. One had burned in the fire. The other, mounted at the far end of the corridor, had survived. She requisitioned the footage that afternoon. The footage showed Marcus Halston entering the east wing at 6:17 in the evening. He was carrying something under his arm, partially concealed by his jacket. He moved with purpose, not like someone who'd wandered in by accident, but he moved like someone who knew exactly where he was going. The timestamp showed him still in the hallway at 6:41. His own statement placed his departure at 6 o'clock. The discrepancy was 24 minutes of lies. Cross submitted a warrant for Marcus Halston's phone records that evening. It took 3 days. When the records came back, they included text messages sent in the week before the fire. Messages from Marcus to a contact listed only as a string of numbers. Messages that the carrier records confirmed had been sent to a prepaid phone, and messages from Marcus to classmates that were harder to explain. One message sent 4 days before the fire read, "Darian thinks he's untouchable. He's not untouchable." Another, sent 2 days before the fire. They read, "He's gonna get what's coming." The investigators cross-referenced the recipient numbers. Several of the exchanges pointed clearly to a pattern of escalating hostility directed at Darian Okafor. The lab results came back 8 days after the fire. Chemical residue recovered from the origin point matched a petroleum-based accelerant consistent with lighter fluid. A partial fingerprint recovered from a fragment of glass near the origin point was submitted for analysis. The analysis returned a match to Marcus Halston's left index finger within 72 hours. The search warrant for Marcus Halston's bedroom was executed 3 days before the arrest warrant. 2 detectives from the county forensic unit accompanied Cross to the Halston house on a Saturday morning with a warrant that covered Marcus's electronic devices, clothing, and any containers or materials consistent with the storage or transport of flammable substances. Marcus's mother answered the door in tears before Cross had finished showing her the paperwork. His father was not home. He worked weekends. Marcus was in his room when the detectives entered. He was sitting on his bed with his phone, watching a video with his earbuds in. He looked up at the 2 detectives and at Cross behind them with an expression that could only be described as genuinely annoyed. Not frightened, not caught. Annoyed, the way a teenager is annoyed when an adult interrupts something they consider important. "Seriously?" he said. "We'll need your phone, Marcus," Cross said, "and we're going to need you to wait downstairs while we conduct the search." "My mom said you could come in," he said, as though that were the source of his displeasure rather than the search itself. "The warrant authorizes us to be here regardless," Cross said. "Please go downstairs." Marcus Halston unplugged his earbuds slowly, placed his phone on the bedside table with deliberate care, and stood. He was tall for 14, the same height as Cross, and he used that height the way adolescents sometimes do when they want to communicate something without saying it. He looked at her for a moment before walking past her to the door. He walked like someone who had decided to cooperate and wanted you to know it was a decision he was making rather than one being made for him. The bedroom search took 90 minutes. The forensic technicians documented everything methodically, photographing each section of the room before touching anything, and the closet contained a pair of shoes that would later be sent to the lab and found to contain chemical traces consistent with lighter fluid on the right sole. A backpack on the closet shelf contained a crumpled receipt from a gas station convenience store, dated the day before the fire. The item purchased matched by description and price a specific brand of lighter fluid sold at that location. The receipt was bagged as evidence. In the desk drawer, beneath a layer of school papers and gaming magazines, a detective found a spiral notebook. The last 5 pages contained writing that Cross read carefully without touching the notebook's cover. her fingers in gloves as she turned the pages. 3 of those pages described, and in the kind of vague but intent-laden language that a 14-year-old might use when writing something they intended only for themselves. A plan for making someone understand what they did and not be able to act like it was nothing. Darian Okafor's name appeared twice. The third time he was referred to as him and that idiot. Cross bagged the notebook. Marcus's phone was submitted to the county forensic laboratory that same afternoon. The lab opened the initial extraction that evening and had preliminary results by the following morning. The contents were extensive and damaging, but the most significant finding, the deleted video file, required a deeper layer of analysis that the standard extraction software would not reach. Cross requested the enhanced examination. The lab director told her it would take 4 to 6 days. She said she would wait. Cross drove to the Halston house on a Tuesday morning with 2 uniformed officers and a warrant for Marcus's arrest. She knocked twice. Marcus's mother answered in a bathrobe, her face still creased from sleep, and the confusion in her eyes shifted to something harder and sadder when she saw the badge. Marcus came to the door behind her. He was wearing basketball shorts and a t-shirt, and he looked at Cross with an expression she had seen before on adult suspects who thought they were smarter than the detective standing in front of them. He looked almost amused. "Marcus Halston," Cross said, "you are under arrest for reckless endangerment in connection with the fire at Redbrook Middle School." She read him his rights. He said nothing. One of the uniformed officers placed the handcuffs on his wrists, and Marcus looked down at them briefly, then back up at the cameras mounted on the front of the neighbor's house across the street. His mother was crying behind him. Marcus Halston did not seem to notice. At the station, Cross led the interrogation herself. The room was small and beige, with a table bolted to the floor and a camera mounted high in the corner. A box of tissues sat on one end of the table, as it always did in that room, a gesture toward the possibility of emotion that went unused more often than not. Marcus sat with his arms crossed and his legs stretched out, like he was waiting for a bus. His court-appointed attorney, a tired man named Gerald Finch, sat beside him and had already whispered 3 times for Marcus to say nothing. Marcus was not listening. The air in the interrogation room was always slightly stale. The ceiling tiles were the kind that absorbed sound, and the room had a particular quality of flatness, no echo, no resonance, a room designed to make the person inside it feel that their words were going nowhere and that there was no performance to be given, because there was no audience. Cross had watched many people discover this fact about the room and react to it in different ways. Some people became smaller. Some people became more desperate. Marcus Halston became more theatrical, as though determined to perform for whatever invisible audience he imagined was watching. "I already told the other officers," Marcus said, before Cross had finished setting down her folder. "I left at 6. I don't know what happened after that." "The security camera shows you in the East Wing hallway at 6:41, Cross said. She placed a still image from the footage on the table. Marcus looked at it. His expression didn't change. "That camera's old. The timestamp could be wrong." "The timestamp was verified against the building's internal clock system," Cross said. "It's accurate to within 30 seconds. Marcus shrugged. "Still could be wrong." "Help me understand something," Cross said. She folded her hands on the table. "You told the officers you left at 6 because you forgot you had basketball practice. Is that right?" Yeah. What gym do you use for practice? Redbrook Community Center. The community center closed at 5:45 on that Thursday. I checked. Cross looked at him without expression. So, if you left the school at 6 to get to basketball practice at a gym that was already closed, where did you go? Marcus's jaw moved slightly, a small recalculation happening somewhere behind his eyes. I made a mistake about the day, he said. Practice was the day before. So you left the school at 6 to go to a practice that was actually the day before? Yeah. Where did you go instead? Home. Anyone see you come home? My mom. Cross wrote something. She knew from the earlier canvas that Marcus's mother had been at her sister's house that Thursday evening until after 7. She said nothing about this. She wrote for a while in green ink. Let the silence sit. Silence was a tool like any other, and she had been using it for 18 years. We also have chemical residue at the fire's origin point, consistent with lighter fluid, and a partial fingerprint from the scene matching your left index finger. She paused. Would you like to explain that? Marcus looked at the ceiling. Then he looked back at Cross. I want to talk to my attorney, he said. It was the first smart thing he'd said since she'd walked into the room. Finch leaned in immediately, and Cross gave them the room. She stood in the corridor and looked at the one-way glass and thought about the notebook from Marcus's desk drawer, about the words, not be able to act like it was nothing, and about Darian Okafor, who at 13 had been given no opportunity to act like anything at all. During jury selection and the early days of proceedings, the 12 members of the jury had formed impressions of the case and of the defendant that were, in their variety and texture, representative of the community from which they had been drawn. They were not permitted to discuss the case during the trial, and they complied with this instruction to varying degrees of comfort. During lunch recesses and breaks, they talked about everything else: the weather, which was still humid and oppressive in early August, their jobs and families, and the various logistics of having been removed from their regular lives for an extended trial. But the case was present in all of those conversations, a gravity pulling at the edges of everything else they said. One juror, a retired schoolteacher named Margaret Chen, had found Marcus Halston's courtroom behavior almost physically difficult to observe, and she had spent 30 years in classrooms and had encountered many varieties of adolescent performance. Boredom performed as sophistication, fear performed as indifference, insecurity performed as aggression. But Marcus's particular performance was something she could not quite categorize, because beneath the arrogance, she could not find the thing that the arrogance was usually covering. He smirked at the cameras, like someone who genuinely believed the cameras were there to document his triumph. She found this more disturbing than any evidence presented in the first week of proceedings. Another juror, a logistics manager named Frank Bauer, had served on a jury once before, a civil case that had lasted 2 days and required little deliberation. This case was different in every way, and he was aware of his own discomfort with the defendant's age, the persistent pull of the thought that 14-year-olds make terrible decisions by definition, that the capacity for premeditation they were being asked to consider was not something a 14-year-old's mind was fully capable of. He held this thought up against the text messages. Darian thinks he's untouchable. He's not untouchable. He held it up against the security footage. He was still wrestling with it when the prosecutor announced, Exhibit 47, and after that, he stopped wrestling. The third juror Cross would later learn most about was a young woman named Tamsin Park, 26 years old, who had attended Redbrook Middle School herself a decade before. She had not known Darian Okafor, but she had walked the East Wing hallway hundreds of times. She knew exactly where the supply closet was. She knew the quality of light in that hallway on a summer afternoon, the way the windows at the far end let in slanted yellow light that turned the linoleum floor into something almost amber. She thought about that hallway when the fire reconstruction expert showed his diagram, and she thought about Darian Okafor walking down it, and she pressed her lips together and looked at the diagram until she had memorized every measurement on it. The arraignment was held 3 weeks later on a humid Monday morning. The Redbrook County Courthouse had been built in 1947 and smelled accordingly, a combination of old paper, wood oil, and the particular mustiness of a building that had absorbed a century of human grief and determination. The gallery was full. Darian Okafor's family sat on the left side, or 3 rows back. His mother, Adaze, wore a dark blue dress and sat with her hands folded in her lap, and did not look at Marcus Halston when he was brought in. His father, Bernard, sat beside her with his jaw set. Behind them, neighbors and community members filled the benches, people who had known Darian, people who had signed the petition demanding a thorough investigation, people who simply needed to be present. Marcus walked in and immediately scanned the room. He found the cameras. He straightened slightly, pulled his shoulders back, and walked to the defendant's table with the practiced nonchalance of someone who had rehearsed this moment in his head. He wore the orange jumpsuit, collar of the white undershirt visible, and if the uniform bothered him, he did not show it. The Honorable Clarence Morrow presided, or he was 61 years old, silver-haired, with a broad face that had settled into an expression of patient severity over decades on the bench. He had seen every variety of defendant that a county courthouse could produce, and he watched Marcus Halston settle into his chair with the measured attention of a man who was already taking notes inside his own mind. The charges were read aloud by the clerk. Reckless endangerment in the first degree. Marcus Halston turned his face toward the gallery the moment the words were spoken, as though checking the audience's reaction. A few people in the gallery exchanged glances, and then Marcus Halston laughed. It was a short sound, barely a breath, but audible enough that the people in the first 3 rows heard it clearly. The murmur that passed through the gallery was immediate and involuntary. Judge Morrow's eyes went to Marcus without any change in expression. Gerald Finch leaned toward his client and hissed something under his breath. Marcus covered his mouth with his hand, but the smile beneath it was still visible. "How does the defendant plead?" the clerk asked. Finch spoke clearly. "Not guilty, Your Honor." The prosecutor, Assistant District Attorney Patricia Nwosu, was a tall woman in her mid-40s with precise diction and a habit of pausing just before she delivered the most important sentence in any given speech. She had been a prosecutor for 18 years, and she had tried cases involving defendants far more dangerous than Marcus Halston. Organized crime, domestic violence with catastrophic outcomes, a hit-and-run case that had taken 4 years to successfully prosecute. As she knew how to carry the weight of a case through the months between charge and verdict, how to keep the work from calcifying into something abstract and procedural, how to remain connected to the human reality underneath the legal framework. But something about this particular case had settled into her chest like a stone in the weeks of preparation. It wasn't the arson. She had prosecuted arson before. It wasn't even the death, though Darian Okafor's death was the moral center of everything she was doing. It was the deliberateness. It was the text messages, written with the casual certainty of someone who had already made up their mind and was simply waiting for the right moment. It was the face in the security footage, moving through that hallway without hesitation, without fear, with the focused purpose of someone executing a plan they had thought through carefully enough to feel confident about. She had seen that quality of purposefulness in adult defendants with criminal histories and entrenched patterns of behavior. She had not expected to encounter it in a 14-year-old. She thought about Darian Okafor every morning when she opened the case file. She had looked at his school photograph for long enough that she could close her eyes and see it precisely. The striped shirt, the grin, the quality of light in the image that suggested a spring day, and a photographer who had said something amusing to get a genuine expression. She did not think about the photograph to motivate herself. She was already motivated. She thought about it to remember what the work was for. The night before the arraignment, she sat in her office with Devon Marsh, and they went through the evidence one more time. The security footage, the chemical analysis, the fingerprint, the text messages, the witness account from Tyrone Fields, which at that stage they had not yet formally taken as a deposition. They laid it all out on the conference table and looked at it together. "It's circumstantial," Devon said. "Most of it. Good circumstantial, but circumstantial." "Fingerprint isn't circumstantial," Nwosu said. "Partial fingerprint. Finch will argue contamination and transference. He'll say Marcus was in that hallway for legitimate reasons and the print got there then. The chemical trace? He'll argue the maintenance worker's testimony establishes existing conditions that might explain anomalous residue. Tyrone Fields, a 14-year-old who may or may not stand firm under cross-examination. Nwosu looked at the table. She picked up the printout of the text messages and read the last one again. "I don't forget stuff like that." She set it down. "What do we have from the lab on the phone extraction? Basic results are back. Texts, contacts, location data. The full forensic extraction, including deleted files, is still in process." "How long?" Lab director said 4 to 6 days. "Tell them 3, Nwosu said. Devon looked at her. "I can tell them. They'll still take 4 to 6. "Tell them anyway," she said. She gathered the printouts into a neat stack and tapped them against the table to align them. "I want to go into that arraignment knowing what's on that phone. All of it." She rose and addressed the court. She outlined the state's case with economical precision, laying out the timeline, the forensic evidence, the witness statements. She described the fire and its origin point. She described the victim. She said Darian Okafor's name clearly and let it sit in the room for a moment before continuing. She concluded by saying, "This case is far from what it appears." She looked at Marcus Halston when she said it. Marcus was whispering something to Gerald Finch. He was grinning. Gerald Finch entered a formal motion to have certain evidence excluded on chain of custody grounds, which Judge Morrow noted for consideration. Finch outlined the defense's position. The fire had been caused by pre-existing electrical faults in the East Wing's aging infrastructure, and Marcus Halston had not been present at the point of ignition. He spoke about the school district's deferred maintenance records about the documented history of electrical issues in that hallway and about the limitations of partial fingerprint evidence. He was a competent attorney making a competent argument, and Marcus Halston sat beside him with an expression of cheerful confidence, as though listening to someone read out his victory speech. The second day of proceedings brought the school's maintenance supervisor, a heavy-set man named Earl Gundry, to the witness stand. Gundry had worked for the Redbrook School District for 22 years. Oh, and he testified in a slow, careful voice about the electrical complaints that had been filed for the East Wing over the prior 3 years. 2 circuit breaker replacements, a flickering light complaint in room 114, a brief outage in the science lab in October of the previous year. Finch walked him through each incident with visible satisfaction, building a picture of a building that had been quietly failing for years. Marcus Halston leaned back in his chair and crossed his arms. He turned his head and found the nearest camera. He gave it a small nod, barely perceptible, but deliberately performed. The jury did not see this. Judge Morrow did. He made no note of it externally, but the observation registered. During the lunch recess, Finch walked with Marcus to a holding room down the corridor. He closed the door behind them and stood with his back against it. Marcus dropped into a chair and pulled out the granola bar that had been left for him on the table. "You need to stop," Finch said. Marcus looked up. "Stop what?" The smiling, the nodding at cameras, the laughing when the charge was read. "This isn't a television show, Marcus." "I know it's not a television show," Marcus said. He unwrapped the granola bar. "Do you? Because you're behaving like you want people to think you're performing. And I can tell you very clearly that the jury does not find that charming. They find it disturbing." Marcus chewed. "The jury isn't going to convict me on reckless endangerment. That's a nothing charge. You said so yourself." Finch stared at him. He had been a public defender for 19 years. He had represented people who were guilty of things that were very hard to think about. And he had done his job for all of them, because that was what the job required, and because his belief in the system's necessity was deeper and more durable than his personal feelings about any individual client. He had long since stopped categorizing his clients by how he felt about their actions. That was not his role. His role was to provide the most competent representation possible within the bounds of the law and ethics. Marcus Halston was making this difficult, not because of what he had done or what Finch suspected he had done, because suspicion was not Finch's job. It was the particular quality of Marcus's confidence. Finch had represented many young defendants over the years, teenagers who had made terrible decisions, teenagers who had been in terrible circumstances, teenagers whose bravado covered a terror so total that it barely registered as fear anymore. He understood adolescent performance. He had learned to read through it, but Marcus Halston's confidence had a different texture. It was not performance over fear. It seemed, as far as Finch could determine, to be genuine. The boy actually believed he was going to be fine, not because he was innocent, but because he had calculated the available evidence and concluded, based on that calculation, that the prosecution's case was insufficient. That calculation worried Finch considerably, because it meant Marcus had thought carefully about the evidence, which meant Marcus knew what evidence existed, which meant Marcus had reason to believe he was aware of everything the prosecution could find. On that word, everything had been sitting at the back of Finch's mind since the moment Nwosu had said, at arraignment that the case was far from what it appeared. He had taken that as courtroom rhetoric. He was less certain now. "I want you to behave," Finch said. "For the rest of this proceeding, I want you to look at the witness, keep your hands on the table, and not make any sounds that are audible to the gallery." Marcus said, "Sure." He said it the way a person says sure when they have no intention of doing the thing they are agreeing to. Nwosu stood on cross-examination and asked Earl Gundry about the specific room where the fire had originated. Room 112, the supply closet adjacent to the science hallway. Gundry confirmed that no electrical complaints had ever been filed for that specific room. None. Not in 22 years. She asked whether the electrical faults he had described were in the same wing, the same section, or even the same circuit system as the supply closet. Gundry shifted in his seat and conceded that they were not. The circuits were separate. The supply closet ran on a dedicated line. Nwosu thanked him and sat down. On the third day, the security footage was introduced. The jury watched the East Wing hallway recording on a monitor at the front of the courtroom. They watched Marcus Halston enter the frame at 6:17. They watched him move down the hallway with the bundled object under his arm. They watched the timestamp at the bottom of the screen, 6:41, still in the hallway, moving toward the supply closet. The footage ended there because that section of the camera's range was blocked by a structural column. A Detective Cross took the stand and walked the jury through the timeline. She was methodical and clear. She described the discrepancy between Marcus's stated departure time and the footage timestamp. She described the attempts to verify the timestamp independently. She described the chemical residue at the origin point and the fingerprint analysis. She was on the stand for 3 hours. During the first hour, Marcus Halston watched her with an expression of mild boredom. During the second hour, he began whispering to Finch with more frequency. Finch kept his eyes on Cross and answered in monosyllables without turning his head. During the third hour, Marcus stopped whispering. He folded his hands on the table and stared at the surface in front of him. Though the expression on his face when Cross described the fingerprint match was one of theatrical dismissal rather than genuine concern. "Partial fingerprints are notoriously unreliable," he murmured, just loud enough for Finch to hear. Finch said, quietly, without moving his lips much, "Please be quiet." The end of Cross's testimony brought the day's proceedings to a close. Nwosu gathered her notes in the corridor afterward, and her junior colleague, a young attorney named Devon Marsh, walked beside her and said, "He's going to be a problem on the stand if Finch puts him up there." "Finch won't put him up there," Nwosu said. "Finch is smarter than that." "Marcus will want to," Devon said. "He wants the audience." Nwosu said, "He's already had more audience than he's going to like." The fourth day brought the chemical analysis report. Dr. Simone Achebe, a forensic chemist with 17 years of experience and 4 published papers on accelerant identification, took the stand. She was a precise, careful woman who used technical language with the ease of someone who had explained complex science to juries enough times to know exactly where to be clear and where to be detailed. She described the process by which samples from the fire's origin point had been analyzed. She explained what a gas chromatograph does and how it separates chemical compounds for identification. She showed the jury a chart comparing the chemical signature of the residue recovered from the supply closet floor with the known profile of a commercial lighter fluid. The match rate was 94%. She explained what that number meant in terms of statistical certainty. She explained what margin of error was present and why it did not affect the conclusion. Is there any scenario in which electrical wiring failure could produce the chemical compounds you identified? Nwosu asked. No, Dr. Achebe said. Electrical fires produce specific char patterns and residue profiles that are entirely distinct from what was found at this origin point. The compounds I identified are consistent with an externally applied petroleum-based accelerant. They are not consistent with a wiring fault. Marcus Halston rolled his eyes at the ceiling. Two jurors in the front row noticed. One of them made a small, almost imperceptible movement with her mouth. The kind of movement a person makes when something has confirmed a suspicion they were already forming. The phone records came in on the 5th day, introduced through a records custodian from the cellular carrier and then contextualized by Detective Cross in a second round of testimony. The text messages were read aloud. Darian thinks he's untouchable. He's not untouchable. He's gonna get what's coming. There were others, less explicit, but equally revealing in context. Messages that described a pattern of resentment building over weeks, escalating in frequency as the school year ended. Several messages referenced specific incidents. Darian Okafor had apparently been central to a humiliating moment for Marcus in the school cafeteria 2 months before the fire, an incident that Marcus had described to a friend in graphic, angry terms, ending with, "I don't forget stuff like that." Marcus Halston sat very still while the messages were read. His jaw was set. For the first time, the theatrical quality of his expression had been replaced by something that looked almost like private calculation. He was running numbers somewhere behind his eyes, reassessing variables, and Finch, who was watching his client peripherally, felt a low-grade unease that he recognized from other cases. It was the feeling of a story that had a chapter he hadn't been shown. On the 6th day, a classmate named Tyrone Fields took the stand. Tyrone was 14, slightly built, and clearly nervous. He answered the prosecutor's questions in a low voice that the court reporter twice asked him to repeat. He testified that on the afternoon before the fire, and he had seen Marcus Halston in the school parking lot near the east entrance. Marcus had been carrying a backpack and something else, something in a paper bag that Tyrone hadn't been able to identify clearly. He had seen Marcus handling something small that caught the sunlight, a lighter. He was certain it was a lighter because he had seen Marcus flick it twice, the small orange flame appearing and disappearing before Marcus noticed him watching and put it away. "Did Marcus say anything to you?" Nwosu asked. Tyrone shifted in his seat. He said, "Mind your business." "And did you ask him what he was doing there?" "I asked him why he was going into the school. He said he forgot something." "Did you see him enter the building?" "Yes," Tyrone said. "He went in through the east door." Finch cross-examined Tyrone at length, pressing on the quality of his observation, whether he could truly distinguish a lighter from any other small, reflective object at that distance in afternoon light, whether he had any reason to misremember or reframe what he had seen. Tyrone answered each question in the same low, steady voice. He was not shaken. He was a 14-year-old boy who had watched a classmate die in a fire and who had decided, after considerable internal struggle, to tell the truth about what he had seen. No amount of skilled cross-examination was going to move him from that. The fire reconstruction expert, Hollis Wade, testified on the 7th day. He brought photographs. He walked the jury through the fire's development using a diagram showing how the blaze had moved from the accelerated origin point outward and upward, consuming the hallway ceiling before spreading through the ventilation system into adjacent rooms. He explained how the presence of accelerant had dramatically increased the fire's initial rate of growth, the difference between a fire that gives people 30 seconds to respond and one that gives people 3 minutes. The East Wing had been consumed in 18 minutes from ignition to structural compromise. Darian Okafor had been in a locker alcove 20 meters from the origin point when the fire reached him. Marcus Halston kept his eyes on the table during most of Wade's testimony. He looked up once when Wade showed a photograph of the origin point, and his expression was unreadable. Judge Morrow watched him from the bench. The judge had developed a habit over 30 years on the bench of watching defendants' faces during the most damaging testimony, not for guilt or innocence, because that was the jury's job, but for something harder to name: a quality of presence. Whether the person in the defendant's chair had any sense of the weight of what was being described. Marcus Halston's face, the judge noted, did not carry that weight. Even now, even during the fire reconstruction testimony, he had the look of someone watching a film about someone else's problem. On the 8th day, Nwosu rose at the start of proceedings and addressed Judge Morrow with a controlled excitement that Morrow recognized as something genuine beneath the professional composure. Your Honor, the state has recently recovered additional digital evidence that we believe is material to this case. We would like to introduce it as Exhibit 47. Finch was on his feet immediately. Objection, Your Honor. The defense has not been provided adequate notice of this evidence. The defense was notified by electronic correspondence at 11:47 last evening, Nwosu said, immediately upon our receiving confirmation of its admissibility from the forensic lab. Morrow looked at Finch. Counsel, have you reviewed the notification? Finch said. I have, Your Honor. I object to the late introduction. Your objection is noted. We'll take a 30-minute recess to allow defense counsel to review the evidence summary. He brought down the gavel. Marcus Halston, who had been watching this exchange with something like his earlier theatrical interest, leaned toward Finch the moment the recess was called. What's Exhibit 47? He said. Finch gathered his papers. He said, I need to go review the disclosure. What digital evidence? Marcus said. His voice was still controlled, still had that quality of performing calmness, but there was a new note in it, a frequency beneath the surface that Finch heard and stored away. I'll come back during the recess and tell you, Finch said. He didn't come back. He spent the 30 minutes in a conference room reading the forensic disclosure with Devon Marsh's counterpart from the public defender's office, and when Morrow reconvened the court, Finch returned to his seat with a face that had undergone a subtle but complete transformation. The mild professional confidence he wore in court every day had been replaced by something careful and guarded, the face of a man who had just been told the load-bearing wall is gone. Marcus noticed immediately. He looked at Finch's face, and his own composure shifted half a degree. What? He said. Finch said, not now. The prosecutor announced that the digital forensics examination of Marcus Halston's phone had recovered a deleted video file. The phone had been submitted as evidence at the time of Marcus's arrest and had been in the custody of the county forensic laboratory. A specialist named Dr. Andrea Voss had been retained to perform a full extraction, including analysis of deleted data, and her examination had uncovered a video file that Marcus Halston had recorded and then deleted within minutes of recording. The file had been identified through a forensic process involving sector-by-sector analysis of the phone's storage medium, recovering data that had been marked for deletion but not yet overwritten by the device's operating system. Dr. Voss took the stand on the 9th day. She was a methodical, deliberate witness who understood that her job was to make complex technical processes accessible without simplifying them to the point of inaccuracy. She explained the structure of a mobile phone's storage system. She explained what happens when a user deletes a file. The phone marks the storage sectors occupied by that file as available for reuse, but it does not immediately erase the data in those sectors. The data persists until the device writes new data over those same sectors. She explained the software tools used to recover deleted data, WADI tools that scan the storage medium at a byte-by-byte level, identifying file signatures, partially overwritten segments, and metadata headers. She had used these same tools in 14 prior cases. She had testified about digital forensic recovery in 7 of those cases, all of which had resulted in convictions upheld on appeal. The gallery was almost perfectly silent during her testimony. This was not the theatrical silence of a dramatic reveal. It was the silence of people who were beginning to understand, step by step, what was about to happen. Marcus Halston sat with his elbows on the table and his chin resting on his folded hands. He was watching Dr. Voss with focused attention, his earlier performance suspended. For the first time since the proceedings began, he looked like a 14-year-old boy. Doctor, that Voss described the metadata embedded in the recovered video file, a timestamp, a geolocation tag, a device identifier. She described how the timestamp was verified against the carrier's network logs and confirmed accurate to within 4 seconds of actual recording time. The timestamp was 6:38 in the evening on the date of the fire. She described how the geolocation data was extracted and cross-referenced with publicly available mapping data and the physical coordinates of Redbrook Middle School's East Wing. The location match was within a margin of 12 meters. She described how the device identifier was confirmed as belonging to the specific phone submitted as evidence in this case. Then she described the content of the video. The video is 11 seconds in duration, she said. It depicts the interior of what appears to be a storage room. The floor of the room is visible, and a liquid is visible on the floor. The recording device is held at chest height. A human hand is visible in the lower portion of the frame. The hand is holding a small lighter. The courtroom was completely still. Is the individual recording the video visible? Nwosu asked. Partially, Dr. Voss said. The recording device is angled in such a way that the lower portion of the subject's face is visible in the frame. The chin, jaw, and mouth are clearly visible. And was a facial comparison conducted? A biometric comparison was conducted between the facial elements visible in the video and the booking photograph of Marcus Halston, taken at the time of his arrest. To the comparison returned a match rating consistent with the standard evidentiary threshold used in this jurisdiction. What about the audio content of the video? The audio is clear and unobstructed, Dr. Voss said. There is one spoken statement captured in the recording. Nwosu said, did you compare the voice captured in the video to any known recordings of the defendant? Yes, a voice pattern analysis was conducted, comparing the audio in the recovered video with 3 known recordings of Marcus Halston, his initial police interview recording, which was taken within hours of the fire, and 2 additional recordings from the subsequent investigation. The analysis compared fundamental frequency, formant patterns, and temporal characteristics. Thus, the conclusion of the analysis was that the voice in the recovered video is consistent with belonging to the same individual as the voice in the known recordings. To be clear, Nwosu said, the geolocation metadata places this recording at Redbrook Middle School's East Wing. The timestamp places it at 6:38 in the evening on the date of the fire. The device identifier confirms it was recorded on the defendant's phone. The biometric comparison confirms the individual partially visible in the video is consistent with the defendant's appearance, and the voice analysis is consistent with the defendant's voice. That is correct, Dr. Voss said. Thank you, Dr. Voss. Nwosu looked at the judge. Your Honor, the state would like to present Exhibit 47. Marcus Halston moved in his seat. It was not dramatic, not the kind of visible agitation that would draw the gallery's attention. It was the small, involuntary shift of someone whose body had just received information before their conscious mind was ready to process it. He had, in the weeks since his arrest, operated on the assumption that the video was gone. He had recorded it on an impulse, watching the flame catch, the satisfaction of that moment spilling over into something that needed documenting for himself alone, the proof of his own cleverness. And then, with the immediate clarity of someone who knows they have done something they should not have documented, he had deleted it within 90 seconds. He had seen enough online to know that deleted meant gone. He had counted on that. He had built his entire composure, his entire performance, on that assumption. The assumption was wrong. Finch put a hand on the table between them. Not touching Marcus, just present. A quiet signal. The courtroom lights did not dim completely, but someone on the prosecutor's technical team had adjusted the ambient lighting slightly, and the screen that had been positioned at the front of the courtroom facing both the jury box and the gallery became the brightest thing in the room. Nwosu pressed play. 11 seconds. It felt much longer. The storage room was visible, exactly as Dr. Voss had described it. The floor. The liquid pooled on the concrete, catching the light from a small window near the ceiling, in a way that made it look almost innocent. Just a spill, just an accident, until the hand came into frame holding the blue plastic lighter. The hand was steady. It was not the hand of someone afraid or uncertain. It was the hand of someone doing something they had thought about enough to feel ready for. Then the sound. A voice. Young. Clear. Confident. A voice that every person in the courtroom who had spent any time near the defendant's table over the past 9 days recognized instantly and completely. Watch this. No one will ever know it was me. The word watch was spoken with emphasis. The kind of emphasis a person uses when they want whoever they are imagining as their audience to pay attention. There was pleasure in the voice. That was the thing that landed hardest in the room. Not the content of the statement, damning as it was. It was the pleasure. The self-satisfaction of a boy who believed he was doing something brilliant. The lighter flicked. The screen showed the first tongue of orange flame catching the liquid on the floor, and the flame spread quickly, much faster than an ordinary flame, fanning out along the accelerant in a low, vivid sheet. Then the video ended. The sound that went through the gallery was not a gasp. It was something smaller and more terrible, the collective intake of breath of people who had hoped for clarity and received, instead, something worse: certainty. A juror in the second row, a middle-aged woman in a green cardigan, covered her mouth with both hands. Her shoulders rose and fell once. The juror beside her looked at the blank screen with an expression that had moved beyond reaction into something calmer and much heavier. In the back of the gallery, a man who had known Darian Okafor's father from church closed his eyes for a moment and bowed his head. Gerald Finch lowered his head. He placed his pen on the yellow legal pad in front of him and left it there and did not pick it up again. He had known, from the moment he read the forensic disclosure the evening before, what was coming. He had sat with the knowledge overnight, and in the morning, and through the technical testimony of Dr. Voss, hoping somehow that the disclosed evidence would turn out to be something less than what the disclosure said. It was not less than what the disclosure said. It was exactly what the disclosure said, and watching it on the screen in the courtroom, with the jury watching and the gallery watching and the judge watching, there was nothing left to argue against it. Marcus Halston's face had changed the moment his own voice came from the speakers. The change was not gradual. It happened in the fraction of a second between the first syllable of watch and the silence that followed me. The grin that had been his constant companion for 9 days of proceedings was simply gone. Not faded. Gone. In its place was something raw and exposed, the face of a boy who had believed with a complete and unexamined certainty of someone who has never truly failed at anything, that he was invisible. His lips parted slightly. His hands, which had been resting on the table, moved involuntarily to grip the table's edge. His knuckles paled. The color had left his face in a way that made him look younger than he was. 14 suddenly visible under the performance. A child who had done something irreversible and was only now, in this room, in front of these people, beginning to understand what irreversible means. He did not look at the cameras. For the first time in 9 days, he did not look at the cameras. Noosu did not speak for a long moment after the video ended. She let the room hold what it had just received. Then she said quietly, "No further questions, Your Honor." Finch did not cross-examine Dr. Voss. He had no questions. He had nothing. The performance was over. Judge Morrow called a recess. Marcus Halston did not stand when the judge left the bench. He sat where he was, staring at the surface of the table, his hands still gripping the edge. A bailiff had to approach him and say his name twice before he moved. When the court reconvened, Judge Morrow looked at Marcus Halston for a long moment before speaking. The room was as quiet as it had been at any point in the proceedings. Morrow was not a man who performed gravity. He wore it naturally, the way a person wears a coat they have owned long enough that it has taken on the shape of their body. When he spoke directly to Marcus, and his voice was measured and without theatrical decoration. "Marcus Halston," the judge said, "I have presided over this courtroom for 31 years. I have sat across from defendants of every age, every background, every variety of circumstance. And in 31 years, I have seldom witnessed the particular kind of performance you have chosen to give in this room." He paused. "You came into this courthouse on the first day of these proceedings with something that you wore on your face like a badge. Not innocence. You wore arrogance. You wore contempt. You looked at the cameras and you smiled, and you laughed when the charges against you were read, and you whispered to your attorney with the amusement of someone who found all of this, the process of justice, the testimonies of witnesses, the grief of a family that lost their child, mildly entertaining. I watched you. Every day, I watched you. And I want you to understand that I was not alone in that watching. The jury watched you. The gallery watched you. Every person in this room formed an impression of you that had nothing to do with the evidence and everything to do with your choices. He leaned forward slightly. But this is not about impression. This is not about the performance you gave for those cameras, or the smirk you wore while a fire expert described how a 13-year-old boy was overcome by a fire that burned faster and hotter than it had any natural right to burn. This is about what you did. And we now know, with absolute and undeniable certainty, exactly what that was. He let those words sit. That video, Marcus, was recorded by your hand, on your device, in your voice. You stood in that room, you poured that accelerant, you struck that flame, and you said, with complete deliberateness and full understanding of what you were doing, that no one would ever know it was you. You were wrong about many things, but most consequentially about that. Another pause. You did not make a mistake that Thursday evening. A mistake is what happens when a person acts without full awareness of the consequences of their action. What you did required preparation. It required intent. It required that you carry a bottle of lighter fluid into a school building, make your way to a specific room, pour that fluid onto the floor, and set it alight. Cass, that is not a mistake. That is a choice, a deliberate, considered, premeditated choice. And the consequence of that choice was the death of Darian Okafor, who was 13 years old, who had a mother and a father and a future that he will never have the opportunity to live. Judge Morrow's voice did not rise. It remained at the same measured, clear pitch throughout. That was almost the most unsettling thing about it. Throughout this trial, you have behaved as though you existed outside the reach of accountability, as though the charge of reckless endangerment was a ceiling that justice could not see past, as though your age or your cleverness or your practiced composure was a shield that the truth could not penetrate. You sat in that chair and you performed the role of a person for whom none of this was real. And you were very good at it, right up until the moment your own voice proved that every word of your defense was a lie told to this court, to this jury, and to the family of the person whose death you caused. He looked at Marcus steadily. The performance is finished. What remains now is what was always going to remain: accountability. Morrow straightened in his chair. You are 14 years old. That is a fact this court takes seriously, as it must. But accountability does not begin at a particular age. Accountability begins at the moment a person understands the difference between right and wrong. And by every indication available to this court, Marcus, you understood that difference, and you chose to disregard it. Yet you chose it with planning and with confidence, and then you chose to come into this courtroom and mock the process by which we as a society attempt to hold that distinction meaningful. He folded his hands. I will not permit this court to be a stage, and I will not permit the family of Darian Okafor to leave this building without having witnessed the full weight of what was done to their son. Beside him, Marcus Halston was no longer looking at the table. He was looking at Judge Morrow with an expression that had passed entirely beyond performance. His eyes were wet. His lower lip was unsteady. He was shaking in the precise, small way that a person shakes when they have been holding their body rigid against something for a long time and the capacity to hold it is finally gone. He opened his mouth and closed it again, but he did not say anything. There was nothing to say, and somewhere inside him, even now, some part of him recognized that. The judge scheduled formal sentencing for the following week, pending the completion of the victim impact phase. Adayeze Okafor took the stand for the victim impact portion with a steadiness that broke something open in the room. She was a small woman with her son's eyes, large and dark and direct, and she sat in the witness chair and looked at no one in particular when she spoke, as though the words were going somewhere beyond the courtroom. She described Darian. She described him in specific, non-abstract terms, the way you describe someone you have spent 13 years memorizing. She described the way he laughed at his own jokes before the punchline. She described his habit of leaving every cabinet door in the kitchen open. She described the textbook he had gone back to retrieve, a science textbook for a class he was genuinely interested in, a class he would have returned to in the fall. She described the moment the fire department came to her car window. She described the weeks that followed with a simplicity that was more devastating than any elaboration could have been. "I am not asking for anything from this courtroom except what is true," she said finally. "What is true is that my son is gone. He went into that school to get a book, and he did not come back because someone decided that whatever grievance they had was worth more than his life." She looked at Marcus Halston for the first time since the proceedings had begun, and her gaze was not angry. It was something past anger, something that had walked through anger and out the other side. "I don't know how to understand what you did. I don't think I will ever understand it. But I need you to know that Darian was real. He was a real person with a real future, and he is gone, and nothing that happens in this room gives him back to us. I want you to carry that. I want you to carry it every day for the rest of your life." Marcus Halston kept his head bowed while she spoke. He did not look up. Sentencing was pronounced at 10:14 on a Tuesday morning, 7 days after the smoking gun had been played on the courtroom screen. Judge Morrow had reviewed the forensic evidence, the testimony, the victim impact statement, and the juvenile sentencing guidelines applicable to a case of this magnitude. He had also reviewed the arguments submitted by both the prosecution and the defense, Finch's submission that the defendant's age and the rehabilitative potential of juvenile detention should anchor the court's decision, and Nwosu's submission that the premeditation, the cover-up, and the specific horror of the outcome warranted the maximum available penalty and transition to an adult facility at the appropriate age. Morrow sentenced Marcus Halston to 25 years to life, with mandatory transition to an adult correctional facility upon the defendant reaching the age of 18, subject to review at each parole eligibility date. He said, one final time, "Accountability does not depend on age when the harm is this severe." Marcus Halston was led out of the courtroom in handcuffs. He was crying quietly as he walked. The sound small and contained, the sound of someone who had not yet developed any vocabulary for the thing that was happening to him. The cameras were rolling. He did not look at them. The gallery emptied slowly. Adayeze and Bernard Okafor walked out together. not touching, each of them inside their own particular silence. Community members who had come every day filed out and stood on the courthouse steps in the August heat. Some of them embraced. Some of them stood alone. Someone placed a photograph of Darian Okafor at the base of the courthouse steps, the same photograph that had appeared in the news coverage since the beginning. A school portrait from the previous spring. Darian in a striped shirt, grinning at something outside the frame. A detective, Lena Cross, stood at the back of the courtroom after the room had cleared and looked at the defendant's table. The chair where Marcus Halston had sat for 9 days of proceedings was pushed slightly out from the table, the way it had been left when the bailiff walked him out. The table surface was clean. The chair was empty. She thought about Darian Okafor. She thought about the 6:41 timestamp on the security footage and the 11 seconds of video that had been buried in the deleted files of a phone and recovered by patient, methodical work. She thought about the green ink in her notebook and the scorch mark on the supply closet floor. She thought about how close it had all come to not being enough, how the case might have looked on the day of arraignment, and the thin and circumstantial collection of a fingerprint and a timestamp and some text messages without what was to come. In the weeks after sentencing, Redbrook County began a process that such communities always begin after such events. The slow, difficult work of trying to ensure that the structures meant to protect people are made stronger. The school district announced a complete review of after-hours access protocols. A community organization founded in Darian Okafor's name began advocating for stricter oversight of juvenile accountability procedures and for clearer legal pathways for cases that crossed the line between reckless behavior and deliberate harm. The state legislature received 3 new proposed bills in the fall session related to juvenile sentencing in cases involving death, and one of them, as named informally for Darian, passed into committee review before the year was out. None of it brought Darian back. Nothing would. But it was what a community does when it has witnessed something that cannot be undone and refuses to let the fact of that witness mean nothing. It was what accountability looks like at the scale of a town. Imperfect, slow, and necessary. The courtroom at Redbrook County Courthouse was used again the following Monday for a zoning dispute. The chairs were the same chairs. The bench was the same bench. The gallery benches bore the same faint scratches they always had, accumulated over 77 years of people sitting in them to witness the machinery of justice at work. The defendant's chair, the one where Marcus Halston had smirked and nodded at cameras and laughed when his charge was read, sat beneath the courtroom's fluorescent lights as it always had, empty and carrying, as all such chairs carry, the weight of every performance and every truth that had ever unfolded before it. Outside, in the August heat, the photograph of Darian Okafor remained at the base of the courthouse steps a little longer before someone carefully moved it to a more protected spot. The grin in the photograph was unguarded and complete. It was the grin of a boy who had no reason to be afraid of anything. On a bright spring morning, in a striped shirt, looking at something just outside the frame that must have been very funny. It was a 13-year-old's grin. It had all the time in the world in it. And it was gone. And it was remembered. And it would be remembered. And in that particular courtroom, on that particular morning, that the last truth that had been spoken was the one that mattered most. Darian Okafor was real. and he would not be forgotten.